Ugandans are repeatedly asked to trust biometric voter verification devices and electronic transmission systems. Yet the legal framework governing these machines is either weak or entirely absent. There is no comprehensive act of Parliament regulating how these machines are procured, how their software is designed, how their security is audited, and how electronically transmitted results can be independently verified. The source code is secret. The servers are in undisclosed locations. Independent audits are not permitted, and stakeholders are asked to simply trust the process. This is not how constitutional democracy works. Technology must enhance democracy. It must not replace trust with blind faith. All of us will remember in 2016, in Amama Mbabazi versus Museveni and Electoral Commission, Presidential Election Petition number 1 of 2016, the Supreme Court of Uganda expressly ordered the Parliament to enact comprehensively legislation regulating electoral technology. Nearly 9 years later, that order has been not implemented. The continued use of biometric machines without the clear legal framework violates the principles of democracy, transparency, accountability, and embedded in Article 61 Clause 1 G and 69 of the Constitution. Section 58A of the Electoral Commission, the Electoral Commission Act, merely permits electronic transmission of results. It does not establish safeguards, audit, trials, or verification mechanisms. There is no provision for independent software, certification, publication, and technical specifications. Real-time monitoring by agents, paper audit trails, mandatory audits, or criminal penalties for system manipulation. When agents cannot verify that machines do, when experts cannot audit the software, and when citizens cannot understand how results are transmitted, technology becomes a tool of exclusion rather than credibility. This directly violates Article 1, Clause 4, because the people cannot meaningfully exercise sovereignty over the process they cannot verify. The military in parliament, a constitutional contradiction. Article 208 Clause 2 of the Constitution is explicit. The Uganda People's Defense Forces must be non-partisan, professional, disciplined, subordinate to civilian authority. Article 209 further prohibits members of the UPDF from participating in political party activities. Yet today, serving military officers sit in Parliament under Article 71, Clause 1C, and vote on civilian legislation, budgets, constitutional amendments, and openly partisan political questions. Parliamentary handset records show that these officers vote overwhelmingly with the ruling party, including on matters such as removal of presidential age limit in 2017 and the extension of presidential term limits in 2005. How can an institution required to be non-partisan participate directly in partisan legislative decisions? How can officers barred from political party activities vote on party-sponsored laws? And how does military participation in Parliament comply with Article 69? 69 is a requirement that elections be free and free from intimidation and improper influence. The commander of defense forces narrative of denial of voters of being at least 20 meters, but instead should go home after voting, raises alarm. During the 2021 elections, soldiers were deployed to opposition stakeholders, regulating or resulting in documented killings, arrests, and intimidation of voters. During the 2017 age limit debates, military officers voted inside Parliament, while armed personnel surrounded the building and blocked opposition MPs. In multiple by-elections, military personnel have been photographed inside polling stations, contrary to Section 75 of the Parliamentary Elections Act, which prohibits armed personnel near polling stations. Democracy cannot survive where the gun and belt are fused. The court now has an opportunity to restore constitutional clarity and public trust. The question is not whether these reforms are necessary. The Constitution already demands them. The question is whether we will finally implement what our supreme law requires. This is the letter. Just 2 pages, 5 questions we delivered to the Electoral Commission on November 18th. Exactly 1 month ago, they received it, they read it, and then they said nothing. 30 days of silence. That silence is the reason why we are standing here today. The violation of journalists' rights, their denial to access information from different areas, torture by security operatives is totally uncalled for. The requirement of presidential candidates paying the mandatory required fee of over 20 million is unlawful under Section 56 of the Presidential Election Act 2005. Requires every candidate to pay non-refundable nomination fee of Uganda shillings 20 million. This fee has no basis in the Constitution and directly contravenes Article 21, Clause 1 and Clause 2. Equality to freedom from discrimination on grounds of economic status. Article 59, Clause 1, on the rights of every citizen to participate in affairs of the government. Article 4, Clause 1, the principle of power belongs to people. The fee effectively excludes citizens of limited means standing for the highest office in the land, hereby violating the democratic principle of universal suffrage. Nomination of presidential candidates should be supported by not less than 100 voters in each of at least 2/3 of the districts of Uganda. 100 voters from a minimum of 98 districts. This quotes at least a minimum of 9,800 voters countrywide. And this is unusual. And this is usually done in a period of not exceeding 1 month. On average, requires an expenditure of at least 3 million. And if it is done in that little time, which is less than 1 month, it can take 300 million shillings to traverse the whole country, meeting those people to support you with their signatures.